Good morning, everyone. I would like to extend a very warm welcome to everyone present in this webinar. Thank you for joining us today. My name is Macklin Pereira, and I'm a paralegal at Fishley & Co Legal Consultants. It is my pleasure to moderate today's webinar on the topic, A Cleaner, Greener but Meaner Shipping, Legal Considerations of the EEXI and CII Requirements. Today's webinar will entail a discussion on the Energy Efficiency Existing Ship Index certification requirements and the carbon intensity indicator regulations, and will be presented by Mr. Chakrapani Bodapati and Ms. Damayanti Singh. The webinar will be for a duration of 1 hour and will begin with a brief introduction by Mr. Chakrapani, followed by a discussion on the steps taken by IMO towards decarbonization and the EEXI requirements. This will be followed by Ms. Damayanti's presentation on the CII measures, highlighting the practical and commercial issues involved therein and the impact on charter parties. I'm confident that the participants will benefit greatly from the insight provided by our lawyers. Upon conclusion of the presentation, we will be holding a 10-minute Q&A session to answer any queries sent by the attendees. In order for the attendees to ask their questions, an icon in the shape of a question mark will be visible at the top right corner of your screen, which will lead you to the Q&A chat box, where you may submit your questions. Please note that the question box will be accessible at all times, even during the presentation. However, the questions will only be published and answered during a Q&A segment after the completion of the presentation. Moreover, depending on the number of questions we receive, we will aim to our best ability to respond to as many of your queries as we can within the time frame for the Q&A section. Now, without any further delay, if I may now pass on the screen to Mr. Chakrapani. Over to you.
Thank you, Macklin, for the introduction. Good morning, everyone, and it's a pleasure to be with you all today morning. As Macklin introduced, my name is Chakrapani, and I'm an off-counsel with Fishley & Co. And I'm joined in this webinar by Ms. Damayanti Singh, who is a senior associate with our firm. As we all know, the topic for our discussion is today, A Cleaner, Greener but Meaner Shipping, the legal considerations of the EEXI and CII requirements. Let's proceed with discussing about these aspects. In today's webinar, we'll be discussing about the winds of change, particularly with regard to the decarbonization, which is a hot topic of discussion in the shipping industry, the possible commercial and legal challenges which decarbonization brings upon with regard to shipping, the time charter parties in an era of decarbonization, how the effect will be felt on the time charter parties, the proposed BIMCO's EEXI transition clause for time charter parties. What is the carbon intensity indicator, and what are the issues which potentially arise with regard to charter parties, and the key takeaways. I'll be dealing with the EEXI requirements, and Ms. Singh will be looking into dwelling upon the CI requirements. There is a global battle against climate change, which we are all aware of. The Earth being a very unique planet, there is a need to leave behind a habitable and a sustainable planet for the future generations. And hence, the climate change needs to be addressed. With regard to this, the decarbonization is a factor which affects climate change and has potential implications to that effect. So before we proceed further, let's understand a few things about what exactly is decarbonization. Decarbonization is a phased reduction of carbon emissions from the ship. Let's consider a ship which has to sail from, say, point A to point B. For example, from Jebel Ali port in the UAE to Savannah in the US. For a ship to sail, obviously it requires its own propulsion power. And such propulsion power is derived by a ship by burning of bunker fuels on board the ship. These bunker fuels are fossil fuels, which means that they are extracted from the earth. And these bunker fuels are a mixture of hydrogen and carbon. So when a ship burns these bunker fuels for power generation, the exhaust of the ship contains carbon compounds, which are carbon emissions. The carbon compounds are potentially hazardous to the Earth's environment. They have damaging consequences like depletion of the ozone layer, increased global temperatures, melting of iceberg, increased sea levels, then drought conditions, various effects. So there is a need to reduce these carbon emissions, and recognizing this need, back in 2018, IMO has adopted an initial strategy on reduction of the greenhouse gases emissions from ships. In this context, IMO has, I should say, set a very ambitious target to reduce carbon emissions by 40% by the year 2030 and bring in a reduction of 70% by the year 2050. Well, the targets are in place, and the question which arises is, how does IMO plan to achieve these targets? That's where the think tank of IMO, that is the Marine Environmental Protection Committee, MEPC, has been entrusted with this job of preparing some framework with regard to reducing the carbon emissions on the ship. And MEPC has proposed certain rules and regulations with regard to reducing these carbon emissions. These these rules and regulations are adopted by IMO and will be entering into force from 1st November 2022 onwards, which is not very far away. The MEPC regulations dealing with carbon emissions have been adopted into the very popular MARPOL Convention, Annex VI of the MARPOL Convention, which deals with air pollution. The point of consideration is IMO has consistently been dealing with issues with regard to pollution from the ships. For example, a typical one is ballast water pollution, aquatic organisms polluting the seas. IMO has brought the regulations dealing with ballast water management in the form of a separate convention. That is a ballast water convention, which we are very familiar about. In juxtaposition, the carbon emission requirements are not brought into implementation by way of a separate convention as such, but rather implemented into the MARPOL Annex VI. This is a loud shout out to the industry that the consequences or the implications of the carbon emission requirements of IMO are going to reach far-reaching effects, because MARPOL is a very popular convention and has got the statutory law in place with several of the flag states. Now, MEPC has proposed certain regulations, and these regulations are with regard to reducing the carbon emission. The regulations are broadly divided into two categories. One which addresses the technical aspects of a ship, the design considerations or the technical management of a ship, and the other which deals with the operational aspects of the ship. Both of them address the ways of reducing the carbon emissions by bringing in a reduction in the amount of fuel which is burnt on the ships. The measures which regard to technical aspects of a ship are the EEXI requirements, that is energy efficiency existing ship index requirements, and those which address the operational parameters of a ship, measures with regard to the operational ways of a ship, are the CII requirements, that is the carbon intensity indicator requirements. If I were to draw an analogy, I would say that the EEXI and CII requirements are similar to a human being's body mass index. Basically, it's the EEXI and CII are indexes. As we are all familiar that a body mass index of 18 to 25 is considered to be a healthy human being. Less than 18 is an undernourished human. 25 to 30 is overweight human, or anything beyond 30 is an obese person. So basically, a body mass index gives about the healthiness of a person. Likewise, the EEXI requirements and CII requirements are indexes or a benchmark which give a light into what is the energy efficiency of the ships and how efficiently these ships can perform. These EEXI requirements and the CII certifications which come therewith are being entering into force from 1st January 2023 through the MARPOL Annex VI. The requirements will be achieved in a phased manner by means of a short, medium, and long-term ways. Let's discuss about the energy efficiency existing ship index. The EEXI is a technical framework to improve the energy efficiency of a ship's design. Basically, it caters to the ways in which the ship can operate by reducing its fuel consumption and proportionately reduce the carbon emissions. Being implemented through MARPOL, this EEXI requirements apply to ships of 400 tons and above. The question is, how are the EEXI requirements met? This is where the classification societies have come to the aid of the shipping industry. And there are various ways in which ship owners can meet these requirements. The most straightforward and simplest way is by reducing the power of a ship. Let's say a ship is of 10,000 kilowatts power and it consumes a fuel of about 35 to 38 metric tons a day. If the ship's power is reduced to say about 70% or even 80%, the amount of fuel consumed is less, and therefore the carbon emissions from the ship are also reduced. Statistics have shown that a mere reduction of 20% in the engine power have greatly reduced the carbon emissions to an extent of nearly 50%. So the straightforward approach to meet the immediate requirement is by reducing the engine power. There are other ways also which can be done. For example, a ship can use alternate fuels like low carbon fuels or zero carbon fuels. There are definitely fuels which are available to this effect, like methanol, LNG, hydrogen fuels, ammonia, various fuels which are there. The other way of doing it is by installing energy efficient technological machinery or equipment on board a ship. These machinery are like the carbon capture technology, where the emissions which are released from the ship are captured by certain equipment, or and alternatively by a mix of hybrid engines, that is a mix of electric as well as fuel power generation. Just like we see in hybrid cars, the same technology of a mix of power generation by fuels and power generation by electrical equipment can be used. Alternatively, there are machinery which can be placed on the ship, like wind sails. Wind sails is a very ancient way by which ships were navigated in centuries back. It's no rocket science. The ship used to sail on with using wind sails. A lot of ample wind energy out at sea, and the energy can be harnessed by putting sails on board a ship. Similarly, wind rotors can be placed on the ship. Or in the alternative, there are certain designs which can be made to the ship's hull, bow, propeller, all of them which can enable a ship to consume less fuel and thereby release lesser carbon emissions into the atmosphere. The MEPC regulations do not, however, prescribe which improvement method should be deployed, and it is at the discretion of the owners, and whichever in consultation with their classification societies, they can employ the ways in which the technological requirements can be modified to the ships. A ship which is complying with the EEXI requirements is issued with International Energy Efficiency Certificate, which is a statutory certificate. Just like a ship has various other statutory certificates like SOLAS certificate, MARPOL certificate, load line certificate, the ISM certificate, liability convention certificate. So this is also a statutory certificate which will be available to a ship with effect from the implementation date. On one hand, the ship owners have an obligation, a statutory obligation to meet with the requirements imposed under MARPOL by way of the EEXI requirements. Ships are also meant to ply and earn freight. So they are, in that process, ships are chartered to charters, typically by way of time charter parties. And the ship owners also have a consequent obligation under the charter parties towards the charterers. So what is perceived in this process is that there are going to be implications with bringing into force the EEXI requirements to charter parties. Let's consider a typical time charter party in which the obligations of the ship owners and charterers are set out. Typically, we all know that a time charter party contains, as far as the ship owners are concerned, a warranty of speed and fuel consumption. That the ship is going to do, say, an X knots of speed at Y tons of fuel consumed per day. Likewise, the ship owners also have a warranty of seaworthiness, which that the ship is fit to do a particular voyage. Suppose the ship is not able to do a particular speed and at a given fuel consumption, then it can have consequences of a breach of warranty. Moreover, in the time charter parties, the charterers have the discretion to order a ship to proceed to a particular port at a particular speed and to load a particular amount of cargo. So the master is at the obligation to comply with the instructions given by the charterers. There are also indemnities which are contained in a charter party that charterers might be required to indemnify the owners for any excess or beyond the charter party conditions. On one hand, the EEXI requirements impose certain conditions on the ship owners, and if the charterers are in breach of those statutory requirements and give excess orders to ship owners, then these can have potential ramifications as to how the relationship between a ship owner and a charter under a time charter party can potentially have. What the EEXI requirements, as I said, coming into force, have certain implications, which there is a lot of uncertainty as to how these implications will be having a real effect. And basically, it requires a lot of discussion and cooperation between the shipping interests, the ship owners and the charterers, and the way ships are operated for the commercial purposes. There are practical considerations which require to be addressed. To meet the EEXI requirements, the primary obligation is on the ship owners by way of the flag state requirement. The ship being governed by the requirements of the flag state. The main requirements to comply with the EEXI requirements entirely befalls on the ship owners. Unless the owners and the charterers agree otherwise, the main obligation falls on the ship owners to meet the EEXI requirements so that the ship meets the demands of a seaworthy condition and due diligence which is required to be exercised by the ship owners. As we mentioned, there are various ways in which the ship owners can meet the requirements of EEXI by way of technical modification, speed reduction, or installing energy efficient devices. So the responsibilities, though they fall upon the ship owner, there will be the issues of allocation of responsibilities, what are the delays which are expected, what are the costs which are expected, what are the suitable ports which have the facilities to dry dock the vessels and do the necessary modifications to meet the EEXI requirements. Another way of looking at things is that the EEXI requirements primarily address about reduction of the fuel consumption. So when there is a reduction in fuel consumption in a typical time charter party, it is the charters who are the fuel is to the account of the charters, and a reduced fuel consumption definitely gives benefit to the charters. Maybe there is a possibility of charters contributing towards the costs. So in that way, there are various discussions which can happen between the ship owners and the charters to allocate their responsibilities. Now, with the EEXI modifications coming into place, it is perceived that there are going to be disagreements or disputes with regard to the modifications which are required, the costs which are involved in it, the impacts which the charters have on the commercial obligations. Thus, there is a need to address this, and the parties need to, the charters and the ship owners need to have some kind of contractual framework in place that the allocation of the contractual obligations of the respective parties are clear with regard to taking out the vessel out of service, the place of dry docking, what kind of modifications are actable so that they do not have any kind of commercial implications to the charters. With this, another aspect which also needs consideration is that the advanced technologies which come into place requires the seafarers to be equipped with their training. Any kind of compliance necessarily comes with a cost. Likewise, in this EEXI also, there is perceived that there are going to be cost implications. So the seafarers need to be trained with regard to their competence levels and training levels so that they are in a position to operate the new technologies which are coming into place. Considering the gray areas which the EEXI can potentially bring in with regard to the charter parties, BIMCO has proposed in somewhere around in December 2021 an EEXI transition clause, which is a model clause which can be incorporated in the time charter parties. This is to bring in more certainty in the contractual obligations of the ship owners on one side and the charters on one side. So that in the lack of which there can be an uncertainty as to who is responsible for what. The key considerations in the BIMCO model clause is that it defines what is the effective date from which the EEXI applies to a vessel. The effective date means the vessel's next annual intermediate or renewal survey, which comes first on or after 1st January 2023. The EEXI also puts forth that the parties, that the ship owner as well as the charterers, accept that the vessel is required to comply with the EEXI requirement from the effective date. And this may require EEXI modifications. The obligation to comply with the EEXI modification is categorically spelled out in the model clause that they shall be completed by the owners. As we have discussed before, the easiest way of meeting with the EEXI requirement is by proportionately reducing the power on the ship. So when a ship's power is reduced, these have consequences on the warranties of the speed and fuel warranties. And considering this, the BIMCO has addressed and provided in this model clause that the new figures which are brought in by way of the new figures of fuel consumption and speed shall replace the corresponding figures which are otherwise mentioned in the charter party. Then there is also the clause also provides that the owner shall be responsible for and bear the costs of some modifications. Any actual loss of time to the vessel shall be to the owner's account. It is not the charter's account, but it's definitely to the owner's account. To bring in this new figures, which come in because of reduced power, the owners are required to provide with the charters with the new reduced speed figures as well as the fuel figures, so that they are deemed into the charter party. The clause also obliges the charterers that they shall not order the vessel to prosecute voyages at speed which would exceed the new maximum speed when implemented. The EEXI modifications other than addition to EPL and Shapoli can be subject to charter's prior agreement and approval, which need not be reasonably withheld by or delayed by the charterers. So a request from the owners that the new figures that the vessel shall sail at a given speed because of the limitations of power will not be withheld or denied by the charterers. So this is where the Binco charter party brings in clarification as to the obligations of the charterers as well as the ship owners. There are definitely the contract arrangement is one, but the practical aspects are yet to be tested, which we will be seeing as time passes, once the EEXI requirements come into place and how they are going to affect what kind of modifications will the owners be willing to consider it, and how the delays are addressed, what kind of cost implications will these modifications bring upon. And considering all these things, the draft model clause is in a manner that it supports the interest of the owners as well as the charterers. The clauses under the Binco clause, the charters have no right to terminate the charter party if the EEXI modification work results in the vessel being off-hire for a significant period. So there are anticipated delays due to the modification, because ports should be available, the dry docking facilities should be available, the machinery which is required should be available. So there are delays which are likely foreseeable in meeting with the requirements of EEXI. So in meeting those requirements, the Binco clause is drafted in such a way that the charters do not have a right to terminate because of these delays, which otherwise is not might be the case in a typical charter party. Now we have seen the implications of on the time charter parties with the EEXI requirement. Another area of consideration is the bareboat charter parties. In bareboat charter party, as we all know, that it is the bareboat charter who assumes the role or steps into the shoes of the actual owner, who can be a bank or a financial institution, but it is the bareboat charter who takes the responsibility of the operations of the ship, the management of the ship, meeting with the class requirements, statutory compliance, the training of the crew, towards the fuel. In every aspect, the bareboat charter steps into the shoes of the registered owner. Therefore, the bareboat charters have an obligation to maintain the vessel in a seaworthy condition with the requirements of the class, and also ensure that the statutory compliance by way of EEXI are required, and any maintenance obligations towards the vessel, they entirely fall upon the bareboat charters. So bareboat charters, in order to affect the technical modifications to a ship, will be required to consult with the registered owners. What are the designs which are acceptable from a commercial point, so that there is a ship is in a better efficient manner which can be it can be operated? What are the structural changes? Consent of the owners will be required. There are potential negotiations, discussions, contractual framework which is required under a bareboat charter properties, so that the technical modifications are not in contradiction to the owners, because at the term, at the end of a bareboat charter party, the charters are required to hand over the ship in a manner in which it was taken over. So there should be an understanding between the ship owners and the bareboat charterer to operate the ship consistent with the EEXI requirements, and as well as at the same time meet the technical modifications to ensure that ships are in compliance with the EEXI requirements, and that there is no potential conflict which otherwise may give rise to leading to an unharmonious relationship between the charterers and the ship owners. With this, now I pass over this matter to Damayanti, who will be addressing the issues of the other index, which is the carbon intensity index. Off to you, Damayanti.
Thank you, Pani. That was, I think, very important as a background to see how the decarbonization will have a wide-ranging impact on everybody, really. And all stakeholders of the shipping industry will have to also adapt to these changes. Now, Chakrapani has dealt with the EEXI requirements, which are, of course, the technical requirements which apply to, or the IMO has put in place to ensure decarbonization. What I will deal with is the carbon intensity index, or the CII, which is an operational measure of how efficiently a ship transports goods or passengers. So what this essentially means is that what is going to be measured is the grams of CO2 which is emitted by a vessel, depending on its cargo carrying capacity, which means the dead weight of the ship, as also the nautical miles traveled, which is the distance traversed by the ship for a voyage. Now, the CII is, I think, a more inclusive metric of measuring carbon efficiency than, say, simply checking the amount of carbon emitted by a ship in a year. This is because, say, for example, during the COVID-19 pandemic, where a lot of ships were docked because world trade was at a low. Of course, carbon emissions did go down, but that was not because the ships were more efficient, but it was only because not that many ships were plying. So therefore, it becomes important to see or to measure this through an inclusive metric, which will actually look at how a vessel is burning fuel and how much carbon dioxide or other greenhouse gases are being emitted. So now the CII will apply to all vessels above 5,000 GT. So therefore, this will mean all vessels which were anyway falling under the IMO's data collection scheme. And this is some 30,000 vessels at the last survey, I believe, that are covered by this. Now, how this will work is that the CII rating will be an annual rating that will be given. And ships will have to essentially put in data in respect of the amount that they have, the distance traveled, the cargo carried, the amount of fuel burnt, etc. And there will be a factor basis which what will be seen is the actual carbon efficiency that was attained by the ship. And this will be compared to the required carbon efficiency, which is a metric that the IMO or the MEPC actually has set out. And on this comparison, ratings will be given to the ship, which ratings will range from A to E. Of course, with A being the more efficient and E being the least efficient. Now, as a minimum, a vessel should have a CII rating of C, which is moderate, or higher, i.e. if a vessel has ratings of D or E, then it will be required to put into action a corrective plan, etc., which we will look at. Right. Now, how this works is that if a vessel has, like I said, a lesser than C rating, then a ship energy efficiency management plan, which is the SEEMP, is needed to be filled in, and the vessel will need to therefore ensure that the SEEMP is followed. What this means practically, of course, is that if, for example, vessels SEMPs become a necessary part of the vessel's documentation, then the ship's statement of compliance could be invalidated if they do not follow it. Again, if the SEMP forms part of the ship's safety management system, then normal charter party obligations such as seaworthiness or due diligence could also be affected. Again, we expect that this will have wide-ranging impact on the industry, because we believe that all vessel Q88s and even for for tanker trades, especially even SIRE or SIRE reports, we also now start including CII ratings to see how the vessel will perform and or how the vessel is rated. Of course, another aspect that may be considered is that, when banks or mortgagees give vessel-related finance, one metric that they may now want to look at is CII ratings of the vessel to decide whether the vessel is compliant. Now, some other practical issues that, of course, arise is that under the MEPC regulations as they stand, a vessel is required to calculate the CII in advance for a 3-year period. Now, the problem, of course, being that for vessels which are on, say, voyage charters or spot charters, it's very difficult for a ship owner to predict with any certainty how the trade is going to be for a 3-year period. So it becomes difficult for them to therefore ensure that the CII rating or the projected CII rating, so to speak, is going to actually comply with the actual annual CII rating when it comes out. Also, again, flag states will have issues because there is no time frame within which vessels must be assessed and verified to ensure that the CII is, the vessel is in compliance with the CII rating requirement. Of course, what this means is that since the flag state does not have a cutoff time to do this, if, for example, the vessel is found to have a lower rating, say a D or an E, it will be difficult again for ship owners to go back and find that causative link to see which exact charterer's order was it, if at all, which led to that lower rating. Again, another issue that we foresee is, of course, under, say, time charters, which are ongoing at the moment, because these regulations, as Chakrapani said, will come into effect from 1st of January 2023. So, of course, we envisage that there are certain charters which are ongoing where delivery or where redelivery will be affected, because by the time the vessel is redelivered, these requirements will have come into force. Unlike the EEXI clause, BIMCO has still not published a CII clause. It was supposed to come out by the end of May, but of course this is a little more complicated. So we take it that it's taking a little more time to also take into account all stakeholder requirements. So what we've done is we've looked at some considerations that will affect the industry when the CII requirements are put into practical effect. For example, the issues of allocation of risk or costs when the CII is put into effect. As we will go forward, and I will take you through the measures by which an owner can be compliant with the CII requirement. We will see that part of the compliance methodology that has been envisaged is to reduce speed or to reduce cargo intake. all of which, of course, will have knock-on effects on charter party compliances, warranties, etc. Again, another major issue that we see is if, for example, the CII rating is not maintained, since it's an annual rating, or it goes down below a certain rating from year to year, then what would be the sanctions or commercial consequences that would follow from that? I.e., would your vessel be blacklisted, or how would it work? Again, the issue again is that the third issue, of course, is how would a lower CII rating have an effect on, say, insurance cover? How would PNI clubs be, would they require a higher premium to insure your vessel? Would a lower CII requirement automatically mean that certain PNI clubs would not cover the vessel, etc.? Now, interestingly, the MARPOL Annex VI, which has set out the CII requirements presently, do not by and of themselves set out sanctions for this for non-compliance with CII. It's not really a sanction-based scheme as has been envisaged. It's more of an incentive-based scheme where flag states, port authorities, etc., have been asked to give incentives to vessels which have a better A and B rating, rather than sanction vessels which have a D and E rating. So really, at the moment, all that will happen if you have a lower rating is that you have to do the SEMP, etc. But we do not know how commercial counterparties will look at it. So broadly speaking, how an owner can improve on the annual operational CII or the index is in 4 ways. First is by operating at a reduced speed. So slow steaming essentially, because that would mean that the amount of fuel which is burnt to travel that same distance is lesser because you're going at a lower speed. The second, of course, is because a metric for the CII is to see that is also where you calculate the amount, the distance traveled by the vessel. You can always, an owner can choose to divert from the shortest route and travel for a longer distance to, so to speak, increase the denominator to put the index lower. Again, one other metric, of course, is the amount of cargo carried. So, of course, if you reduce the cargo intake of a vessel, irrespective of its deadweight, then that could also be a way to be compliant with CII. And of course, like Chakrapani said, there is energy efficient technology that you can put, that you can do. But again, unlike the EEXI requirements, the CII is an operational measure. So really energy efficient equipment may to a certain extent reduce your carbon or make your ship more carbon efficient. But in the long run, you will still have to fall within those metrics. And since there's an adjustment factor, the energy efficient technology will also be included in that. Now, of course, the issue is that these measures that the owners can take may obviously put them in breach of existing contractual obligations and or obligations, because most standard form charter parties that are in play in the market as on date have never taken into account these requirements that have now come in. So, for example, charterers' orders in respect of, say, employment of the vessel or issues such as demurrage, off-hire, etc., could all potentially impact the vessel CII ratings. Obviously, there has to be a balance between all stakeholders. So we cannot expect owners to fully bear the responsibility of this only because it is the vessel which must be CII compliant. But also, on the other hand, like I said, since the traditional charter parties do not have these clauses to cater to this situation, charterers as on date still are contractually correct if they say that they need their orders to be followed. Of course, this also leads to certain other knock-on effects, like say, for example, if the vessel reduces its speed and therefore arrives late, there could be certain other third-party claims, such as say from cargo receivers for late delivery of cargo and or damage to cargo. Now, let us look at how these options that the owners have and what are the potential implications under a charter party. Now, of course, the issue is that these all will have to be negotiated during a fixture, because none of these are things that the owner can unilaterally, none of these are measures that the owner can unilaterally take, and it must be done with the agreement of its counterparty. So of course, now if a owner say reduces speed or slow steams, this may place the owner in breach of speed and performance warranties in the charter party. Of course, this may also lead to say off-hire claims and or equitable set-off against hire, because say the owner had warranted that the vessel would say sail with X speed at X knots. Again, the issue of say taking a longer route to reach the port could lead to breaches of say utmost dispatch or due dispatch obligations. Again, charterers often give employment orders saying, proceed with utmost dispatch to discharge port. There could be a clear breach of these instructions if the owner deviates from the route. Again, there could be issues of say P&I coverage being invalidated because wrongful deviation is something that some clubs do not cover. Again, increasing distance sailed is similar, where ship owners could potentially face say off-hire claims and or equitable set-off against hire. Now we come to reducing cargo intake. Now the issue with this is, of course, that when a vessel is fixed, owners do make certain express cargo warranties that, so to speak, about the amount of cargo that the vessel can carry. These are often included in, say, the vessel's description or the Q88, etc. And what happens is that, of course, if the owner unilaterally reduces the cargo, then it may face itself in breach, and or due diligence warranties may also be called into question. Now, what are the effects of these so-called breaches? Of course, we do not think that these breaches by and of themselves will lead to rights of termination, but they could lead to claims and damages. Of course, this depends on the wordings of specific charter parties, so we're giving a general overview here. Slow steaming and or deviations could lead to triggering of off-hire clauses, deductions, etc. Another thing from the owner's perspective is, say, for example, in a void charter party where owners, if they reach and tender NOR and lay time is over, but say the berth is not available, a demurrage incurs, which again is a potential source of income for the owner. But if now they reduce their speed so that they reach at a certain point, and we will look at this again with respect to a BIMCO clause, a potential issue, of course, is that this may lead to them losing money which they could have potentially gotten from demurrage. So this is again a commercial consideration that must be looked at. Of course, there are general common law principles such as doctrines of frustration and or implied indemnity, but at the end of the day, these are all very fact specific, and what must be looked at is how parties have essentially negotiated and or drafted bespoke clauses to deal with this situation. Now, let us look at how void charter parties will be affected, because one aspect, of course, is because void charter parties are, unlike time charter parties, where, say, charterers have the right to direct the vessel for a period of time. And in a void charter party, owners, of course, have full control of the vessel. So therefore, they may be able to, amend the clauses of the charter party or tailor it, so to speak, for their requirements. However, again, similar issues as in time charter parties will arise, because there would be there may be potential issues of utmost due dispatch breaches and or speed consumption warranties. For example, under English law, and especially in the context of voyage charter parties, there is an implied duty to proceed on a voyage without unnecessary deviation. Now, obviously, we will need to see, of course, this is an old principle, but we'll need to see how this plays into charter parties or voyage charter parties now with these new requirements having come in. Again, P&I clubs may have an issue with giving insurance cover because P&I clubs may not defend claims because club rules often say that, you know, there is no recovery for deviation and or cargo, etc. Again, the amount of cargo loaded, as I said, if you reduce the cargo intake, this may again put you in breach of express cargo warranties in your charter party. Now, what is interestingly, before this happened in 2021, the BIMCO had actually drafted a just-in-time arrival clause, which essentially was a departure from the in voyage charter parties, the traditional, you know, steam fast then wait approach with compensation accruing for demurrage, etc., to a just-in-time approach where what is envisaged is that owners and charterers will share information, and through that information, you know, charterers may reserve the right to say, okay, do not arrive before X date because we will not have a berth available. This, of course, plays into the CII requirement because if a vessel comes in and is waiting at a port, it is still burning fuel, and therefore, again, its CII the index may go down. So therefore, it may be better if owners and charterers can decide between themselves to adopt this clause or a similar clause where they decide to share information and the charterer says, okay, do not arrive before X because a berth will not be available. Now, how an owner can be compensated, and which is what this clause looks at, is to say that, okay, the amount of money that I have lost because of this loss in time or at a fixed rate is something that the charterer will compensate the owner for, thereby giving, you know, a balance to commercial considerations. But of course, the problem with this is, of course, this was not done with only decarbonization in mind. And therefore, if there is, for example, a minimum speed consumption or speed or performance warranty in the CP, that and by and of itself may lead to non-compliance with the CII regulation. So this will itself, these clauses will by themselves need to be again tailor-made and or amended to suit the purposes of the CP. Now we come to COAs. Now, of course, COAs, the issue is, since there are parcels of cargo which are being taken, if owners either reduce cargo intake or if they reduce their speed under the COA, the number of parcels lifted may, of course, be reduced, and this may place them in breach of the COA. So, of course, owners may have to argue that, you know, there was an implied duty which applied given the new regulations which came in, but of course the change in circumstances by these regulations being brought in will have to be looked at. With that, one small thing that I would like to briefly touch upon is another push towards decarbonization, which is being done, but it's mainly being done in the EU, which is the emissions trading scheme. The reason I wanted to bring this forward is because the BIMCO has very recently published the emission trading scheme clause for time charter parties. Now, what it is, very briefly, is that the European Commission has basically published a package of proposals aimed at reducing EU's net greenhouse gas emissions, similar to the IMO. Included in this proposal was, of course, a proposal for reducing carbon dioxide emissions. Now, under this ETS scheme, the shipping company is responsible for compliance, which is essentially any company which is assumed responsibility for operation. So these could also be ship managers, it could be bareboat charterers, etc. Now, of course, under this, the shipping company is required to monitor, report, and verify that emissions are in compliance, failing which there are fines, there is blacklisting, and therefore it's a lot more sanction based than the CII requirements by and of themselves. BIMCO has, as I said, published an emissions trading scheme allowance a clause for time charter parties, where the principle underlying the clause is that the party providing and paying for the fuel under the time charter is also going to be responsible for providing or paying for emissions trading allowances. So this will work on a carbon credit method, where companies will have to buy carbon credits and thereby use them. Now, the reason we thought that we should also discuss this is because this is something that we envisage may also slowly be adopted by the IMO and or the shipping community at large eventually, if this trial run that the EU has done actually works out. Because again, this also feeds into the entire push towards decarbonization. To conclude, I think the three main things that we should take away from this is that A, it's still uncertain. I mean, the regulations are just coming in. We do not know how they will be put into effect in practice. But the idea, of course, is that we must start now to cater our charter parties and our commercial requirements to these things, because the decarbonization is here to stay. And that being so, it is important to strike a balance between owners' requirements, for example, to maintain their CII requirements, and charterers' commercial requirements to employ their vessel, to meet their obligations under third-party contracts, etc. So, therefore, we believe that bespoke clauses may be the way to go, at least until BIMCO publishes a CII clause. It is also important for parties to not only closely cooperate, but also to share information, because it is not just ship owners and or charters which are affected. It is the industry as a whole which is affected by these. With this, I invite Chakrapani also to give any closing remarks that he has.
Thank you, Damayanti. That was very helpful. Yes, these EEXI requirements and CII requirements are new, which are yet to be tested waters. We have to see how the shipping industry is going to accept the requirements and how their matters are addressed. Challenges to shipping industry are nothing new. In fact, we have seen right from the days of Titanic, where the concept of watertight holds was brought in, which was not something which was heard of at that point of time. The Exxon Valdez and Prestige brought in the concept of double hull tanker. Before that, ships were flying with a single hull. The sulfur and NOx emission regulations have required the ships to operate on low sulfur fuels, which was initially being used in specific regions. Now, low sulfur fuel is a common norm, which is available to most of the ships, and thereby the sulfur emissions and SOx emissions, whether by way of low sulfur fuels or scrubbers fitted. The shipping industry, despite the challenges which have been confronted to them by regulations, have already accepted most of them and implemented. So I'm quite optimistic, despite the uncertainty with the EEXI and CII have, that these also will be favorable and definitely in the interest of the people, so that we have the less harmful effects of the carbonization. And with that, I pass over to Macklin for any further things.
Thank you. Thank you, Chakrapani and Damayanti, for giving us a very insightful presentation and highlighting the practical issues involved here. I can see that we have quite a few questions coming in, and since we are short on time, I'll try and redirect to you a few questions. And in case we are not able to answer any questions, we will be sure to email you the answers as and when the questions come up. Okay. So we have the first question here, which is, will consumption in ports impact the CII requirements?
Thank you, Macklin. I will take that. Yes, consumption in ports may. The problem is that the CII requirements and or the regulations are still a little unclear as to what exactly will happen. But since the CII rating will be basis the carbon or the fuel consumed and the carbon emitted throughout the year, if, for example, a vessel is at a port idling, it is still burning fuel, and therefore we would expect that these would also be consumed within the CII requirement or used as a metric while calculating. Over to you, Macklin.
Yeah, thank you. Thank you, Damayanti. The next one we have is, how is this data reported and who will certify the data? Chakrapani, Damayanti, will you take this?
I will take that. So, of course, again, insofar as the CII, the data will be, so the flag state is the nodal authority which will be giving the certification. So, as I said, all the vessels which fall within the CII regime are above 5,000 GT and therefore already fall within the IMO's data collection, the DCS regime. And therefore, all of this data is already being recorded for these vessels. So what the flag state will have to do is, of course, now it's a very technical calculation that is there because there's an entire formula along with a adjustment factor. But the flag state is supposed to essentially do that calculation and give the CII rating to the individual vessel, which is, of course, registered with it. Thank you.
Thank you. Thank you, Damayanti. The next question we have here is, what would happen to older tonnage ships which are not able to comply with EEXI requirements due to constraints to adapt to new alternative technologies?
Yes, I'll answer that, for a ship, let's say a ship which is about 18 or 20 years old, and it has a requirement to meet with the EEXI requirements from 1st January 2023. The easiest way which can be done is by reducing the horsepower. But whereas with the other modifications like adaptability of the ship to newer fuels or newer technology, installing new machinery or equipment, they might not be cost effective for the owners. So during a particular phase, the ships will will operate, and ultimately the oldest tonnage required to be scrapped, giving way for more efficient new ships to come and operate. Over to you, Michael.
Yes, thank you. Thank you, Chakrapani. The next question we have is more on the impact of the ratings. The question is, would the IMO or authorities give rebates to vessels or owners or charterers with better ratings?
That's actually a very interesting question. As far as CII is concerned, we believe so, yes. I do not know if the IMO per se will give any rebates, but how the CII regime is supposed to work is, since it's more of an incentive-based regime than a sanction-based regime, if a vessel has a better CII rating, the IMO has encouraged flag state and or port authorities to give certain incentives. Now, what those incentives are, I believe, is left up to these nodal authorities to decide by themselves. But the interesting part is that we do not know how charterers or any other third parties will be incentivized by this, because at the end of the day, a charterer may well say, okay, great, I am helping you get your vessel a better rating, but What do I have of it? So that may be a commercial issue that may have to be dealt with, but may not be something that the flag state by and of itself be able to give an incentive for.
Thank you, Damayanti. We'll just take a couple more questions. One that we have here is, how are the EEXI or the CII requirements going to affect shippers and consignees of goods carried by sea?
I'll answer that. The EEXI and CII requirements are going to impact a ship in the short interim by reducing the speed. Ships will be required to reduce the speed so that less fuel is burnt, the carbon emissions. From a shipper's standpoint, he would require his cargo to be delivered at a port of delivery on a given date. So with the delay, with the reduced speed, there are obviously delays which are going to come into place. There can be claims of delay by the shippers, and alternatively, the disputes leading against the ship and the charterers. So these are the kinds of implications or claims which might arise from a shipper in a ship owner on his obligation trying to meet the requirements of EEXI. Over to you, Maklan.
Thank you, Chakrapani. And with respect to our previous question that Damayanti was dealing with, we have a comment by Jasmine who says that insofar as the UA is concerned, no incentives have yet been considered here. So that is just as an update to what Damayanti was discussing. The next question we have here is, are these regulations applicable in any way to the bunker suppliers?
Again, an interesting question. I believe that bunker suppliers, insofar as CII may not be affected so much, because we've already had a host of IMO regulations with respect to, less carbon bunkers, etc. But I'm not sure insofar as EEXI whether bunker suppliers, Chakrapani, will bunker suppliers be affected?
Not to a greater extent, Damayanti. The bunker suppliers are obliged to supply a particular grade of bunker. But going forward in the long run, then the availability of the new fuels is definitely going to a challenge, which will have some kind of implications with the bunkers in different ports, because we are looking at bunker supplies from the east of Earth to the west of planet. So there are ports which supply with the new fuels, the other places which are not available with new fuel. There might be a dearth of new fuels, for example, like supply of hydrogen bunkers. They need special vessels for that purpose. The bunkers, so these are not in the imminent. I don't see a imminent implication as of now. But going forward, yes, there should be an infrastructure in place for a bunker supplier to provide alternate fuels.
That is correct, Chakrapani. I think that's the sensible way forward, is where all of these methods would at the end, I think, all complement each other, so to speak, to increase the push towards decarbonization.
Yes, ma'am.
Thank you, Chakrapani and Damayanti. We'll take a couple more questions because we have a few more remaining in the Q&A chat box. So the next one is, how would improving ship fittings impact CII?
Well, again, if, for example, a ship is made more carbon efficient through increasing the ship fittings, it would more affect the EEXI, because that is again a technical aspect of the ship than the operational. But of course, any ship fitting which makes the ship more carbon efficient would automatically lead to a better CII rating. But in the long run, since it's an annual rating where vessels are required to, improve their rating, so to speak, if possible, year to year, once a ship fitting is done, it would of course be used as an adjustment factor in the next year's rating. So it may not, so per se, in the long run, of course, it will make your ship more carbon efficient, but per se, it would be more of an EEXI requirement than a CII requirement.
Thank you, Damayanti. We are now moving to the last question for today. And that is, what kind of implications will EEXI requirements have to ship owners towards training and competence of seafarers operating the ship?
I'll answer that, Maclean.
Okay, Chakra.
Any compliance, a general thumb rule is for a ship owner to comply with any kind of statutory compliance, costs are involved. The EEXI requirements come with monitoring the fuel consumptions, installing new technologies, using new fuels on board, maybe a mix of different kinds of storage facilities of the new fuels. Hydrogen fuels and all require containment in a more safer ways. The use of those fuels, ammonia, suppose if ammonia is a fuel which is to be used for a ship. Ammonia is an extremely hazardous fuel. So there should be a fail-safe systems where the use of these fuels do not impact the seafarers. So seafarers will be required to meet the training and challenges which the EEXI requirements have to bring upon. That requires more training facilities worldwide with diverse seafarers from Philippines, the European Union, India, or the Asian countries. So what is expected is that the seafarers require more training and competence levels, which will for the ship owners need to comply with that aspect.
Thank you, Chakrapani and Damayanti, for answering all the questions of our participants and for engaging us in such an interesting and relevant topic. I thoroughly enjoyed it, and I hope that our participants as well benefited from your presentation. We have now arrived at the end of our webinar. Thank you everyone for participating and for the support. Please follow us on LinkedIn and Twitter to stay updated with all our new webinars and articles. Thank you.
Thank you.